My name's Catherine DeVerne, and I'm the Dean of the Allard School of Law, and I'm very pleased to welcome all of you to the 2020 Marlee Kline Lecture in Social Justice. As we begin this evening, I'd like to acknowledge that we're here on the traditional, ancestral, and unceded territory of the Musqueam people, and we are grateful every day to share this land and this space. The year 2020 marks the 75th anniversary of the law school, and we are celebrating throughout the year with a number of special events and initiatives. And one part of as part of this celebration, one of the things that we are doing is we are focusing on inviting alumni back to deliver the majority of our named lectures, and that includes, of course, the Marlee Kline Lecture this evening. So the Marlee Kline Lecture honors the memory of Marlee Gayle Kline, who was a member of the faculty from 1989 to 2001. After losing Marlee far too soon, her colleagues, students, friends, and most especially her family joined together to establish this annual lecture. We're grateful that every year members of Marlee's family join us for this event, and I'd like to extend a special welcome to every member of the family, and most especially to Marlee's parents. It is very gracious and generous of you to share Marlee's memory with us in this way. Marlee's work on feminist legal theory and critical race theory, child welfare law and policy, and on law's continuing colonialism is internationally acclaimed. Marlee insisted on a complicated intersectional understanding of the way law affects societies and Canadian society in particular. This lectureship not only recognizes Marlee's rich contribution to the law school community, but also reflects her passionate belief in the central role of social justice in legal education. So it's my very great pleasure to introduce this year's guest lecturer, the Honourable Lynn Smith. And I'm just going to continue mumbling up those words. You will be so glad when I turn over officially to Lynn. After receiving her LLB from this university and clerking for the Chief Justice of British Columbia, Lynn practiced law at Shrum, Little and Hebbenton, which is now morphed and absorbed into McCarthy-Tétrault. She joined the faculty here in 1981, and she served as dean from 1991 to 1997. Her term as dean was a very important time, especially for the role of social justice in the law school. Lynn led the fundraising for Canada's first chair in feminist legal studies, which, now that I have some sense of what that entails, I find even more remarkable than in previous versions of my own role. And we're very happy to have the first incumbent of that chair, Susan Boyd, with us this evening. Thank you for coming, Susan. The fact of the chair meant that Susan could be hired and join the faculty, and very shortly after she joined us, she founded the Centre for Feminist Legal Studies, which is the home and host for this lecture. During Lynn's term as dean, the law school opened the Indigenous Community Legal Clinic. It made a significant shift in its research culture, and it celebrated its 50th anniversary. So in preparing for the 75th anniversary, we looked back to see if we could find any inspiration in the patterns of celebration of the 50th anniversary, and found, in fact, that it's quite humbling, and we probably can't aspire to those heights even if we have 10 events. So, you know, but we invited Lynn back anyway. Lynn Smith was appointed to the Supreme Court of British Columbia in 1998 and sat as a justice on that court until her retirement in September 2012. She has received every award and honor that the legal profession in this province bestows upon those that it most admires, and so I won't list them all. And she also was honored by Simon Fraser University with an honorary doctorate in 2004. After her retirement, we were very lucky at the law school in that she has rejoined us as an honorary professor, and she teaches a seminar on charter litigation. And I don't know if there are students from that seminar here tonight, but it is probably not possible for people taking that seminar to understand how lucky you are. And I understand you have a co-teacher this year who's also pretty impressive. So Lynn also serves as a mentor for doctoral students through the Pierre Elliott Trudeau Foundation, and in her ample free time, she has just completed a term as the Acting Conflict of Interest Commissioner for British Columbia. Please join me in welcoming the Honourable Lynn Smith to the podium.
Well, thank you very much, Catherine, Dean Dauvergne, for those extremely kind words. And I just want to begin by saying how honored I am to have been asked to deliver this lecture. I am most appreciative to the Kline family and to the UBC Faculty of Law for supporting this event. I was on the faculty when Marlee and Joel came here, and then I worked with them both as a colleague and as a dean. I believe that Marlee would have been as anxious as I have become about the topic that I'm addressing today, the problem of misogyny as it manifests itself online, and the limits of the law's ability to address that problem. Joel is here tonight, and so I expect him to answer the difficult charter questions in the Q&A that follows. Before I go further, I want to acknowledge the excellent work of my extraordinary research assistant, Emma Moore, of the third-year law class. There she is. Thank you, Emma. And I also thank Dr. Chris Tenove, a UBC-based researcher who's been working intensively on the policy options available for dealing with harmful speech online. The general context of the topic is vast. The impact of cyber technology on our societies, our democratic institutions, the acculturation of our young, our very minds and brains, our ability and motivation to distinguish truth from bias and from lies. The specific problem of hatred directed against women online is acute, and it clearly has no single simple solution. So why did I choose this topic, you may well ask? In part because of some contrasts that have struck me. The first one relates to proceedings against Doug Collins in the 80s and 90s in this province. Mr. Collins was a columnist for a local newspaper called the North Shore News. Some of his writings became the subject of human rights complaints, alleging that his publications promoted hatred against Jewish people under Section 7.1 of the British Columbia Human Rights Code. By the way, he also published vituperative stuff about feminist women. The terms feminazis and jackboot feminists were some of my particular favorites. But what struck me is that what Doug Collins published in print in the early 1980s, the anti-Semitic stuff that was the subject of those complaints, it would seem almost subtle and ridiculously trivial in comparison with what is regularly published online in 2020. It stood out at the time. Today it would be lost in the torrent. And Collins's writing actually reached a very limited number of people. Today's online hate has the potential of enormous reach. The second contrast is more positive. It's between two instances of alleged judicial misconduct. The first in the 1970s, involving a BC provincial court judge, and the second in 2016 involving Justice Robin Camp in Alberta. The earlier instance involved the late Judge Les Bewley, who said in a sentencing hearing of a man who had threatened his girlfriend with a knife. Sorry, that's the wrong one. But we'll get there. Who said in a sentencing hearing of a man who had threatened his girlfriend with a knife, quote, "So I could give him 5 years," said Judge Bewley, "but I don't think I'd be entitled to, because as we clearly have said before, he got mixed up with a silly little bunch of girls who meanwhile they got scared because he was proving himself a macho man, was going to haul one of them out and talk to her, even if she got scared and ran into the bedroom. So we've got a bunch of clucking females running around, and they're all so scared that they have to call the police." Judge Bewley later said, quote, "Even if he had stabbed the woman, it would not be any loss to society." Also said, quote, "Women don't get any brains before they're 30. Now, the Provincial Judicial Council heard a complaint against him and concluded that, Yes, it was improper for him to say that if the accused had stabbed the victim, it wouldn't have been a loss to society. It said that some of his remarks were off color and in bad taste, expressed disappointment that he couldn't express himself with more care, but it dismissed the complaint, and he remained on the bench. By way of contrast, I refer to the Canadian Judicial Inquiry in 2016 into the conduct of Justice Robin Camp. He had presided over a sexual assault trial, and that inquiry reported, quote, "Sexual assault law and sexual assault trials are laden with concerns about gender equality, bias, and discrimination. Justice Camp's manifest failure to behave impartially and to demonstrate respect for equality in such a context over a protracted period of time has raised considerable public concern about how women who allege they've been sexually assaulted are treated in the justice system," end quote. That judge was removed from the bench. Well, what connection do I see between the treatment of alleged judicial misconduct and my topic today? My point is that in Canada, the charter value of equality sometimes weighs significantly in the scales, even in a context as protected as that of what a judge says from the bench, the context of judicial independence. And I will be suggesting that Canadian constitutional norms permit and may indeed require more concerted action to restrict online hate speech than has been seen in the United States. So there are these two contrasts between 40 years ago and the present. One, a huge increase in the volume and reach of harmful speech, including misogyny expressed online, and two, a significant increase in the weight that Canadian courts give to equality, including gender equality, when they're required to strike a balance between equality and other charter rights or values. The values that permeate the online world, the world created by major internet companies like Facebook/Instagram/WhatsApp, or Google/YouTube, or Twitter. Those values are those of the United States and its Constitution, specifically the First Amendment, with its guarantee of freedom of expression, and the 14th Amendment with its guarantee of equality. In Canada, we have developed significantly different constitutional doctrine in both of those areas. Here's a simplistic version of the difference. In Canada, we see freedom of expression in less absolutist terms than they do in the US, and in Canada we have adopted, I admit it sometimes incoherently, a substantive understanding of equality that goes beyond simply requiring same treatment. So this lecture is in 4 parts. I'm going to address the nature and scope of cyber misogyny, then talk about what we can expect the internet companies to do about it and what they're currently doing. Third, I'll look at some legal options in Canada and refer to the balancing or reconciling of charter rights. And finally, I'll venture a few thoughts about the future. Now, I'm going to manage your expectations if they need any further management. I don't claim to have become an expert in the field of digital media studies, nor do I have an original theory or proposal to put forward. A few nights ago, I was expressing consternation about what I've taken on tonight, and a colleague, I think trying to be helpful, said, well, a fresh set of eyes on a problem can be a good thing. Well, we may be at a useful good time for a review with fresh eyes. In the UK and other European countries, there are new and proposed new regulations to address online harmful speech, and the Canadian government has signaled that it plans to tackle this issue. I'm going to turn now to the nature and scope of the problem of cyber misogyny. And as is often observed, the World Wide Web has proved to be a great force for good and for the opposite, great benefit and detriment. A New York Times Sunday magazine issue captured this point using the internet cliche of an amusing photo of a cat. And the issue was entitled, "So, the internet didn't turn out the way we hoped." Very true. There we go. And certainly I think would all agree that the internet did not turn out the way we hoped in some important ways. For one thing, it's become a highly effective tool for the distribution of deliberately misleading and sometimes dangerous material, designed to influence public opinion, political decision-making, or even healthcare choices like vaccinating our children. It's also become a place for the promulgation of hate, including woman hatred or misogyny. I'll begin with one example. In her 2013 book called No One to Tell, former RCMP member Janet Marlee describes the relentless bullying and sexual harassment that she experienced during her 20 years with the RCMP, and she talks about her decision to come forward publicly. She writes, quote, "I steeled myself for attacks from some elements of the organization whose integrity I was calling into question, but I was completely unprepared for the anonymous attacks online." She writes, "The commenters let loose with a fury of accusations disparaging me and the other women who had come forward to share our stories. The caustic remarks didn't just question the validity of what we'd said, they maligned our character, questioned our motives, labeled us as weak complainers jumping on a bandwagon. Some went so far as to denigrate my appearance. I was, after all, too ugly to be sexually harassed. It was crushing. I had put myself, my whole identity out there in the public realm, and these people were hiding behind their computers and the smoke screen of their usernames, spewing scorn." End quote. Janet Marlee's experience was not very unusual. In fact, several recent and credible reports have shown that cyber misogyny is pervasive and widespread, that it is not just a first world problem, and that its effects extend well beyond the virtual world. In 2015, the UN Broadband Commission for Digital Development released their report called Cyber Violence Against Women and Girls, a Worldwide Wake-Up Call. The report concludes that cyber violence against women and girls is a systemic problem worldwide, and the Commission suggested that the opportunity to spread misogyny online or to abuse individual women online is inviting for those so minded because of these factors. There we go. These factors. First, anonymity. An abusive person can remain completely unknown to their target. Second, it's action at a distance. It's like shooting from a fighter plane to distant little figures below. Action at a distance. It can be done without any physical contact and from anywhere. It's automated. It requires little time and effort. It's accessible. The technology is available to many, many perpetrators. And then it's propagated wildly and often perpetually. The texts and images multiply and exist for a long time or even indefinitely. A truly chilling illustration of the impact of perpetuity is the experience of people, men and women, who were abused as children in order to create video footage depicting that abuse online. From a New York Times report, quote, "Many of the survivors and their families said their view of humanity had been inextricably changed by the crimes themselves and the online demand for images of them, and, quote, I don't really know how to deal with it," said one woman who at age 11 had been filmed being sexually assaulted by her father. She said, "You're just trying to feel okay and not let something like this define your whole life. But the thing with the pictures is, that's the thing that keeps this alive." In 2018, a European Parliament report found that these figures were supported by their survey. 14% of all women reported cyber stalking since they were 15, 11% reported cyber harassment, and overall cyber harassment of women between ages of 18 and 24 was 20%. The Pew Research Center in the US and an Angus Reid survey in Canada, 1 year apart, showed very similar figures, that men and women reported roughly similar levels of harassment, but women were 2 or 3 times more likely to report sexual harassment, or comments based on their appearance rather than other kinds of harassment. Women were more likely to describe it as having an impact on their real lives or as being a major problem. There were considerably higher rates among young people visible minorities, LGBTQ people. And a significant number reported a possible chilling effect, with 61% of social media users saying they've decided not to share content because of their fear of unwelcome responses. And for people who don't use social media, 37% attributed that non-use to the problem of offensive content. There was a report prepared by Amnesty International. It was called the Troll Patrol Study. And it looked at millions of tweets received by 778 journalists and politicians. It found, of course, that there were some threats of murder or rape or misogynist slurs, and that some 7.1% of the tweets were either abusive or problematic. Interestingly, women of color were 34% more likely to be mentioned in such tweets than white women, and black women were 84% more likely than white women. A very recent report came out. It was reported in the New York Times. A survey of U.S. mayors found that 79% reported being the victims of harassment, of threats or other psychological abuse, and this was either online or offline. But female mayors were more than twice as likely as their male counterparts to experience psychological abuse, and about 3 times as likely to experience physical violence. So we find ourselves, and there are many studies and the statistics are fairly comparable. So we find ourselves looking at what certainly is a serious problem, and I can add that I've been told personally by several female British Columbia political people, female politicians, that online abuse can be absolutely relentless, that it seems to be getting worse, and that it creates a real deterrent to participation in public life. The internet also enables the coordinated harassment of particular women through the sharing of non-consensual intimate imagery, and this is often called revenge porn. And I don't need to recite the details of what happened with British Columbia, a young woman, Amanda Todd, who died by suicide after sexual extortion by a man over the internet. Even adult women who are victims of sextortion or the sharing of non-consensual intimate imagery online often describe living in a state of constant fear and anxiety. And part of this arises from a practice of revealing online the personal information of targeted women, such as their home addresses. This is called doxing, and it can have a huge impact. Women have lost their jobs and have been forced to move their homes after publication of non-consensual intimate imagery and harassment that follows. A common pattern with abusive ex-partners or schoolmates is dual track abuse, where offline violence is displayed or furthered through online messaging. And then this is amplified with images and videos from one set of violent relationships being made available for consumption more broadly. And finally, a form of online misogyny that appears to have contributed to real-world homicides is the so-called incel community. That word incel is short for involuntarily celibate. Now, a male sense of entitlement to women's bodies is not unprecedented, but the internet has provided an easy forum for men with this mindset to radicalize through meeting online. And the perpetrator of the 2018 van attack in Toronto, which killed 10 people, identified as an incel and has since been declared a hero by many within that community. I'd now like to turn to the second part. What can we expect the internet companies to do, and what are they doing? Well, the existence of cyber misogyny and hate speech has been known for some time, and the large internet providers have indeed begun to respond. Facebook and Twitter, in different ways, attempt to limit what can be shared online, both before and after the fact. And by and large, they've done so voluntarily, but very slowly. It's been voluntary because providers of interactive computer services are in the US immune from liability for most harms caused by user-generated content, as a result of paragraph 230 of the Communications Decency Act. In the U.S., federal criminal law prohibits child pornography, but not in general hate speech. The exception being speech that incites imminent lawless action. According to Kline, the purpose of this grant of immunity was A, to encourage platforms to be good Samaritans and voluntarily take an active role in removing offensive content, and B, at the same time uphold First Amendment values. She addresses this interesting question. Why did they do it? Why, despite the near immunity under Section 230 and the robust support for unlimited free speech in the United States, have the large internet companies chosen to invest resources in regulating content on their sites? She suggests that essentially several reasons. One, they're economically motivated to create a hospitable environment for their users. Two, for economic reasons based on advertisers' decision-making, and possibly for reasons of social and corporate responsibility. I'll ask you for your comments on that later, Joel. It may be that the possibility of governmental regulation outside the U.S., as it has occurred in Germany, also plays a role. Content codes promulgated by the companies have been increasingly detailed. There are sometimes levels of appeal and remedial options, and it's not a big stretch to see them as privately designed and privately administered legal systems. Indeed, Facebook has announced plans for its own equivalent of a Supreme Court called an oversight board. The oversight board is to interpret Facebook's content policies in light of Facebook's articulated values. It'll be able to instruct Facebook to allow or remove content, to uphold or reverse a designation that led to some enforcement. Indeed, in an announcement that came out today naming the first director of the Oversight Board, one commentator announced breathlessly, it will even be able to overrule Mark Zuckerberg, which is actually true. I mean, it is exactly the way that is. So I've been talking about Facebook, just a brief word about Twitter. It's gone probably through the biggest change in recent years. A senior VP of Twitter once referred to it as, quote, the free speech wing of the free speech party. And some of the events leading up to the change, a tempering of its position, were harassment campaigns against women, including the campaign against the woman who was mercilessly harassed for suggesting that Jane Austen be put on the UK currency. What a travesty that would be. And of course there was Gamergate and a number of other high-profile issues. The primary ways that content online is moderated are artificial intelligence and human monitors. These often work together with AI flagging potential violations and then a human being making the final decision. Artificial intelligence algorithms are pretty good at detecting things like spam or nudity, but they're much less effective at detecting the nuance and meaning of speech. And a real concern, I think, that many have raised is that the lower level content moderation by humans has been outsourced. It's been outsourced to private contractors in the US or overseas. And the participation in this industry raises a number of serious worker safety concerns, particularly about the mental health of the frontline workers who are required to view large quantities of violent, pornographic, abusive materials shift after shift after shift. As I'm sure everybody in this room knows, it's now possible for users of the services to take steps to protect yourselves with muting or blocking or reporting, and I think this has to be quite helpful. However, some have argued that it amounts to an abdication of responsibility by the internet companies, offloading responsibility to individual users. Particular issues like non-consensual intimate imagery has been addressed, for example, by Google, which allows users to request that such images be de-indexed, so they won't show up in a name search. Some mainstream pornography websites, such as Pornhub, also have reporting functions for flagging a video as being a non-consensual intimate image and having it removed. But while the internet companies obviously have primary responsibility, we can't rely on them to address the problem entirely. First, they simply lack the power and reach to deal with the more extreme cases of cyber misogyny. They can try to monitor and intervene, but they've no control when the abuse spreads to other sites or offline. Second, the dark corners of the internet are essentially unpoliced and operate on a complete open access basis. And third, the companies can't carry out comprehensive real-world investigations, and nor can they provide legal remedies. And finally, and this is the point I was making earlier, most of the big providers are based in the US, governed by its laws, and informed by its values. I mentioned earlier the broad immunity granted by Section 230 of the Communications Decency Act, and I'm told that some scholars are questioning whether the US-Mexico-Canadian Free Trade Agreement will mean that US laws like Section 230 will limit the extent of possible Canadian regulation of the internet. So another problem, and this cuts in many ways, it's that the interpretation and enforcement of the internet companies' codes is pretty obscure. There's little clarity about why some posts stay up and why some are taken down. It's more or less a black box, although I suppose there's a few twinkles of light into the black box. In short, global content moderation at scale poses an enormous challenge. Can even these behemoths, Facebook, Google, Twitter, that have created and profited from these global systems really solve the problems that their systems have created? Many have been asking that question. I'm going to move to the third part now, which is the law. We're at a law school. It's a lecture in honor of a Canadian law professor, and so inevitably that's where I now turn. Two preliminary points about Canadian constitutional law. First, the Canadian Charter of Rights and Freedoms applies to limit government action, but it doesn't apply to limit private corporations or other private actors. As an example, it's in some doubt whether the Charter freedom of expression guarantees can be invoked against universities, although the Alberta Court of Appeal recently held that the Charter does apply in that context. Second, the division of powers in the Canadian Constitution allocates authority over interprovincial or international modes of communication to the federal parliament and not to provincial legislatures. Thus, communication over the internet is under federal jurisdiction. There are civil remedies like injunctions or damages that might be available under tort law like defamation or copyright law or privacy law, but these generally have to be invoked through a privately funded civil lawsuit. And the barriers are high to accessing these civil remedies, and the outcome's fairly uncertain. So I'm not going to spend time on civil claims, and instead I'm going to turn to criminal and human rights laws. So there are public law remedies through Canadian criminal law and human rights law. First of all, let me point out that a number of criminal law provisions do limit expression in one way or another. It's a long list. I won't read it out loud, but contempt of court, advocation or promotion of terrorism, and so on. And there are anti-hate laws. Anti-hate laws were enacted in Canada in 1970 in response to the report of the Special Committee on Hate Propaganda in Canada, called the COHEN Committee, after its chair, Maxwell Cohen. In striking language that still resonates, the committee referred to the 18th, 19th century belief that reason will prevail, and the reference to Milton, who said, "Let truth and falsehood grapple, whoever knew truth put to the worse in a free and open encounter." The committee referred to that and then said, "We cannot share that faith today." And in the last portion of this quote, "The successes of modern advertising, the triumphs of impudent propaganda such as Hitler's, have qualified sharply our belief in the rationality of man. We know that under strain and pressure in times of irritation and frustration, the individual is swayed and even swept away by hysterical emotional appeals. We act irresponsibly if we ignore the way in which emotion can drive reason from the field." And the committee report led to Canada's hate crimes, anti-hate criminal laws, which prohibit advocating genocide, publicly inciting hatred, and publicly communicating statements willfully promoting hatred. However, proceedings require the consent of the Attorney General of Canada, and of course the criminal standard of proof beyond a reasonable doubt must be met. And there have been very few prosecutions under those sections. I will note that the Anti-Terrorism Act in 2015 added some new offenses aimed at willful or reckless communications that attempt to incite others to violence. And in 2015, I was talking about publication of intimate images. It did become a criminal offense under section 162.11 to distribute intimate images without consent, including distribution online. Now, these anti-hate criminal laws have been upheld as constitutional. And this is as good a time as any to remind ourselves of the wording of the key charter provisions. Section 2, there's the freedom of expression guarantee. It's thought, belief, opinion, and expression, including freedom of the press and other media of communication. And then, of course, Section 1, which allows for reasonable limits prescribed by law that are demonstrably justified in a free and democratic society. Those are two key provisions, and here's the third, Section 15, which protects equality. In the Keegstra case, the Supreme Court of Canada found, sorry, let me just go back one slide. In Keegstra, I'm sure we all remember that case, but I'll just briefly describe it. There was a high school teacher who was forcefully teaching anti-Semitism to his students. And the constitutionality of the anti-hate provision was challenged, and the Supreme Court majority found that although there was an infringement of freedom of expression, the provisions did constitute reasonable limits and were upheld in the end under Section 1. Notably, the Keegstra case applies today, and a BC court has held that it continues to be binding in the context of an online publication. I referred earlier to differences between US and Canadian approaches to freedom of expression, and we just looked at Section 1. In Keegstra, the Supreme Court majority, in a judgment written by Chief Justice Brian Dixon, adverted to this distinction, saying, and I'm sure you can't read it from where you are, I'll just read the last part. Chief Justice Dixon said, "We must not hesitate to depart from the path taken in the United States. Far from requiring a less solicitous protection of charter rights and freedoms, such independence of vision protects these rights and freedoms in a different way. As will be seen below, in my view, the international commitment to eradicate hate propaganda and, most importantly, the special role given to equality and multiculturalism in the Canadian Constitution necessitate a departure from the view reasonably prevalent in America at present, that the suppression of hate propaganda is incompatible with the guarantee of freedom of expression." So that concept, that suppression of hate propaganda can be compatible with the Charter guarantee of freedom of expression, has led to the Supreme Court's conclusion that not only the criminal code provision, but also federal and provincial human rights legislation directed at hate speech is constitutional. The court noted that freedom of expression is not the only charter right that may be relevant. In Whatcott, a 2013 case, Mr. Whatcott had been distributing anti-gay pamphlets in Saskatchewan, and he had to answer to a complaint under the provincial human rights legislation. The court recognized the serious impact of hate speech, noting that it, quote, seeks to delegitimize group members in the eyes of the majority. But it upheld the key human rights provisions that were under attack, although it struck a couple of clauses down. Mr. Justice Rothstein, Marshall Rothstein for the court, wrote, "We're required to balance the fundamental values underlying freedom of expression," I continue, "with competing charter rights and other values essential to a free and democratic society, in this case a commitment to equality." So let me say a few more things about human rights legislation. It does apply to everyone. Complaints may be brought against individuals, corporations, and governments, and it has a purpose of rectifying discrimination and compensating those who are harmed by it, rather than, as in the criminal code, simply leading possibly to punishment. But the barriers to accessing the human rights system, although they exist, are lower than they are for the civil justice system. There is a provision in the British Columbia Human Rights Code that prohibits publication of statements, notices, signs, symbols, or other representations that are likely to expose a person or a group or class of persons to hatred or contempt. So why couldn't British Columbia human rights legislation be used to file a complaint about harmful speech or hate speech online? Well, if provincial laws applied, the British Columbia Human Rights Code could do that. But it's probable that provincial human rights legislation doesn't apply because of the division of powers under the Constitution Act, which gives legislative authority over interprovincial or international modes of communication to the federal government. So someone can decide to promote hatred through paper pamphlets on Monday and online on Tuesday, and the Human Rights Code would allow for a complaint to be filed about the Monday activities, but not the Tuesday ones. Well, I said it was federal jurisdiction. What about federal human rights legislation? The problem is that at the moment there is a gap. Until it was repealed, Section 13 of the Canadian Human Rights Act made it a discriminatory practice to communicate telephonically any matter likely to expose a person or persons to hatred or contempt by reason of their identifiability on a prohibited ground. There was a lot of criticism about Section 13. It was grounded in freedom of expression values. It was argued that it was a tool for political correctness and that it conflated offensive speech with hate speech. Those arguments prevailed in 2013, and Section 13 was repealed, and it remains off the books. However, I note that 3 current federal ministers received a mandate letter saying that the issue is back on the federal government's agenda and they are to do something about it. Now, often, as I've suggested, and as Whatcott illustrates, in Canada, issues about about hate speech involve balancing freedom of expression against equality or reconciling the two sets of values. And the Supreme Court of Canada early on rejected any notion that there would be a hierarchy of rights under the Charter, with, for example, the fundamental rights and freedoms taking priority. It also rejected the notion that the legal rights, such as the right to a fair trial, would take priority. So we can see a number of examples, cases like Trinity Western, where freedom of religion rights had to be reconciled with the Charter value of equality. A number of cases involving the constitutionality of laws restricting the ability to cross-examine in sexual assault cases and the like. Laws where there were provisions designed to prevent the use of myths and stereotypes in sexual assault cases, Mills, Barton, and so on. So you have the balancing, and the value of equality is given some weight. Now, what does this mean with respect to misogyny online? I think that the Canadian constitutional jurisprudence says that we must try to maximize the extent to which all Canadians can enjoy not only the right to freedom of expression, but also the right to equality and the right to life, liberty, and security of the person. Misogyny can stifle the voices of those who are subjected to it, instill fear, and lead to physical danger. It can have severe impacts on the dignity and equality of women, and we shouldn't overlook the principle in Section 28 of the Charter that says that the rights and freedoms are guaranteed equally to male and female persons. Protecting our freedom to express political and social ideas against state-imposed restrictions is a vital goal and a key element of the Charter, but just as vital is our ability to achieve equality for women and others subjected to historic discrimination. For women, for all women, to achieve equality, among other things, they must be able to participate fully in public life. Participation in public life through voting, standing for office, sitting on juries, sitting as judges, serving on police forces like the RCMP, all of these are only recently available to Canadian women after many centuries of exclusion and relegation of women to the private sphere. But participating in public life has a new meaning in this decade. It To many, it means participating in discourse on privately owned, privately governed, American managed, basically unregulated platforms. Though it may be difficult for people who don't actively engage with social media, like me, to understand its importance to those who spend their lives there, I think I have to take their word for it. It's centrally important. To say to somebody who's been abused online, well, just leave Twitter and Facebook, just don't look at them, is not a realistic option. And it's wholly impossible for someone who wants to stand for public office or engage politically. So I hope I won't be taken as in arguing for concerted action to curtail cyber misogyny as misunderstanding or understating the importance of freedom of expression. It is, of course, a pillar of our democratic society, a pillar upon which we all depend. The fact I can stand here and say these things today shows that I'm resting on that pillar too. We all do. But surely deliberate and harmful untruths motivated by hatred and designed to undermine the very democratic institutions that protect freedom of expression can be distinguished from robust political discourse. I come to the last and briefest part of my talk, a few thoughts about what can be done. Well, first, let me say the obvious. We shouldn't lose sight of the fact that without the misogyny, there would be no cyber misogyny. Let's continue to work toward a world without misogyny, in which woman hatred is not a thing. Realistically, the most the law can ever be expected to do is prevent the worst forms of expression of it, or maybe a lot of expression of it. But preventing misogyny, not just its expression, must be the goal. That said, I agree with the authors of Poisoning Democracy, How Canada Can Address Harmful Speech Online, Dr. Chris Tenno, Dr. Heidi Tworek, and Dr. Fenwick McKelvey, that concerted, coordinated, and evidence-based approaches must be devised and executed with the cooperation of governments, federal and provincial, and the community, and careful balancing the values of freedom of expression, equality, and democracy. These efforts should include the creation of a regulatory scheme. It could require audits to determine if social media companies violate the rights of protected groups, for example, by exposing them to hate speech or violent threats. It could encourage the development of and adherence to codes of conduct. And we could create institutions like the Broadcasting Standards Council with the mandate of developing, monitoring, and promoting sectoral codes of conduct. In addition, we can ensure that Canadian law enforcement personnel and judges are well informed about cyber misogyny and its impact, including that cyber misogyny is very much an intersectional phenomenon, with particular significance for racialized women, women with disabilities, transgender women, Indigenous women, and lesbian women. We could also consider more draconian schemes, such as Germany's law, effective since 2018, NetzDG. It imposes very serious financial penalties on internet companies, 50 million euros, for example, that do not swiftly and accurately identify and act on illegal speech online. So to repeat what I argued earlier, though the internet companies show increased commitment to content moderation, possibly, maybe, even some receptivity to state intervention, they need and should receive direction from democratically elected governments, such as the Government of Canada. And here's a modest proposal. Among other measures, the Government of Canada should reinstate Section 13 of the Canadian Human Rights Act, and once again allow for human rights complaints based on internet-facilitated communication of hatred. That would again permit individual complaints, and it would clarify to the internet companies that the parameters of Canadian law are defined by at least two goals: maximizing the freedom of expression and maximizing the promotion of equality. Thank you.
Well, good evening, everyone. I'm Deborah Parks. I'm the chair in feminist legal studies here. I have the privilege of occupying that chair after Susan Boyd's retirement. I've been here since 2016, and I was a student of under Lynn Smith's deanship. I see Francesca Marzari here, also from my class, and others of us who have benefited from the amazing work that that Lynn Smith has done over the years to really pioneer and develop the notion, the understandings, the deeper understandings of substantive equality that are so fundamental to Canadian constitutional law, to human rights law, and across a whole range of other legal matters. And as you were talking about today, we now have a lot to think about in terms of how those norms and values relate to some of the most pressing issues of our time. And I just want to thank you for speaking to us today and for all the work that you've done over the years, and including challenging us today with this call to action. So thank you, Lynn. A little token of our thanks. And so we are at full time, so we are going to say any questions that you have will be taken up over refreshments in the just outside of the room here. Please join us for as long as you can to chat with our speaker and to everyone else who's here. Thank you all for coming this evening.